Chairman, then, in closing, unfortunately, I won't promise to be brief, but I'll be as brief as I can. One time I promised a judge to be brief, but it was a pretty miserable case. I didn't have any evidence at all as a defense attorney, except trying to win the sympathy of the jury and get them to nullify the law. And so I thought the longer I talked, the more tired they'd get, and maybe they'd give in. And finally the judge said, only a lawyer could have referred to that as brief. I'll try to be briefer than that today. The law, ladies and gentlemen of the board, has been broken, and we've proven that. We've proven it in the first portion of the hearing. We've proven it today. They have violated the law that requires them to coordinate with all of your local governments. That's a black and white law. NEPA requires it. The Federal Land Policy Management Act requires it. The Clean Air Act requires it. The Clean Water Act requires it. The Endangered Species Act requires it. Every single environmental statute that was passed during those closing days of the Nixon administration requires coordination. And the requirement of coordination has never ended. The Homeland Security Act requires it. As a matter of fact, I had a supervisor from Del Norte County call me and said, I don't suppose they put this in Homeland Security. I said, I doubt it, but there it is. It's because Congress recognized in the 70s, and probably recognizes it today more than they did then, that the agencies have the power to roll over local government. And one of the reasons they do is because local governments don't recognize what the authority is that they've been given. It's one of the best kept secrets in federal and state law. And one of the reasons that the Department of Justice doesn't like these cases to get into court is the more they get into court, the more people will realize they have the authority. And Lord knows what the agencies would do if they actually had to begin to coordinate with counties and cities. They don't even do it with the states, much less doing it with local governments, much less doing it with an irrigation district, which I represented in Montana, against the Fish and Wildlife Service, one of the most vicious of all of the agencies. In addition to the statutes that have been violated on coordination, the CARB has violated the most basic laws of morality. Coming out of the Second World War, the Nuremberg Code, with the amendments that were made to it and the additions that were made to it, they have conducted human experiments with something by injecting into the noses of a 10-year-old child and by putting adults in a sealed compartment and exposing them to the exhaust of a diesel engine in violation of the Nuremberg Code, in violation of the Common Code, federal law, and state law. And with regard to that 10-year-old, you don't even have to go to those high-class laws to find a violation. The state of California has said there will be no experimentation on children under 16, with or without consent, and with or without consent of their parents. And no one has called CARB, EPA, USC, or UCLA to justice for violating that law. In addition to that, EPA has a rule that says there shall be no human experiments on children under 15. Their own rule. and they violated, with millions of dollars in grants to the universities that Dr. Dunn named, millions of dollars in grants to USC and UCLA for the specific purpose of children experiments. The EPA went to Congress and explained that they had ended all of the human experiments when somebody on a committee happened onto the evidence that they had, thanks to Dr. Dunn and Stephen Malloy. And they said, oh, we quit that, we ended it. We did it for 20 years, but we ended it. We introduced evidence in Reading that they continued those experiments for 2 years after they told Congress that they had ended them. And so they lied to Congress, but why not? They violated every other law that Congress has passed that governs them, so why not lie to them? The case law that emphasizes coordination. In the state of California, the Attorney General Jerry Brown, when he was Attorney General, filed an action against the Department of Agriculture claiming that they were not coordinating with the state of California with regard to a forest management plan. Now, that case was filed in the Northern District of California, and it's Department of Natural Resources versus the USDA, Department of Agriculture, U.S. Forest Service. And the Forest Service came in and said, oh, we met with them 100 times. We met with them, we discussed details, we discussed conflicts between their position and ours. And the court said, but you didn't attempt to reach consistency. You didn't make that last attempt to reach consistency. And they said, well, we couldn't do that because the state wouldn't be reasonable. And the court said, well, that's too bad. You go back and start all over again. And the Forest Service plan was thrown out. It went back to the planning stage with the state of California, and within 3 months the matter was settled, and the Forest Service did what they should have done to begin with. But they wouldn't do it without the court enforcing it. In the state of Utah, in Uintah County versus the BLM, Gail Morton, you'll find that I really don't know. We've made a few tests over the years as to which is the most sued federal agency for violation of law. And we were hoping that the BLM, who were working in grazing, were hoping the BLM would win out. They didn't. The Forest Service eased them out. And now EPA is in a dead run to beat everybody out, with 5 to 6 actions being filed against the EPA each week in the federal courts. But in Utah, the county had a plan for the public grazing lands, calling for putting no more wild horses on the grazing lands. And the reason was that there was a disease that was running rampant among the wild horses, and cattle were not immune from it, and so it would harm the cattle that were lawfully grazing the land, plus the fact that the horses had grown in number so much that they were depleting the forage that the ranchers were paying for. And so their plan said no increase in horses. The BLM met with them, discussed with them, had coffee with them, talked to them, and then increased the horses. And the district court in the District of Utah set aside the BLM plan and said it is invalid because you made no attempt to reach consistency with the county. You talked to them, but you didn't reach consistency. And so they threw the plan out and sent it back to start over. In Idaho, in the American Farm Bureau and Hawaii County, Idaho, versus Bruce Babbitt, I think, might have been his predecessor, I don't know, over the Bruno Hot Spring snail. The Bruno Hot Spring snail was a microscopic snail that was listed as an endangered species for the purpose of cutting cattle off from the water that the snails lived in. It's a very hot artesian water with some of the highest temperatures that are reached by the hot water sources and aquifers in the United States. And a professor from Stanford had come to Idaho on vacation to look at these hot springs pools, hot springs ponds. And he found a big black spot on one of the rocks. Couldn't tell what it was, so he got out his microscope or his magnifying glass. He could see that there were tiny, tiny things on there. He had never seen one before, so he named it the Bruno Hot Springs snail. He came back the next year and looked, and the spot had decreased by maybe 1/3 of an inch in diameter. And so he petitioned to have it listed as endangered, because it was decreasing in number and was known nowhere else in the world, because he had never seen it anywhere else. And the county commissioners in Owyhee County were really, they didn't believe that the government would do this and grant endangered status to a species on that basis. I told them they would, because it would mean that immediately they could get the cows off the water, and immediately they could tell the ranchers that they could pump no more water for irrigating the forage for the winter feed. They listed it as endangered, and it took 3 days for the Bureau of Land Management orders to get to the ranchers. Cows off the water, no more irrigation. There were operating loans for the ranchers that were on the bankers' desks ready to be signed, and they were withdrawn because of the species. Well, we argued against the endangered nature of it, and the Farm Bureau argued the scientific basis, and we argued the fact that the Endangered Species Act requires that Fish and Wildlife go to the local government before any decision is made about a species and coordinate with them. And really, the Department of Justice laughed at us, because Owyhee County has less than 10,000 people, 3 commissioners who sit at that time twice a month, and they could not believe that the secretary really had to confer with these, as they called them, backwoodsmen, not understanding that we didn't have any forests in Owyhee County, so we didn't fit the backwoodsman category. I had a friend in the Department of Justice that I had left to come out here, and he called me and he said, "What the hell are you doing in Oahu County?" I said, "Well, it's not Oahu, it's Owyhee." And he said, "Well, where did the name come from?" I said, "The story is that some Philippine sailors got drunk and lost, and they didn't know how to say Owyhee, and they didn't know, they mispronounced Hawaii, and it became Owyhee." Now, I doubt that, because there's no water that those sailors could have gotten from there to Owyhee County within hundreds of miles. But the point is, he said, "They've asked me about this plan and this argument that you're making, and they wonder, is there anything to it?" And he said, "I looked at it and I said, well, if Grant's making it, there's something to it. He may be wrong, but he may win." The district judge in Boise ruled that because they had not consulted and coordinated with those 3 county commissioners, he struck the listing of the Bruno Hot Springs snail. Well, we're in the 9th Circuit, so when the appeal went up, we knew we would lose. But in the meantime, Fish and Wildlife wasn't so sure, and they came to us and they began to say, "Look, let's coordinate." And the first thing we coordinated about was the spotted frog. The BLM was trying to force them to list the spotted frog so that they could cut grazing in the northern part of the county. And they said the BLM is turning in figures every year. They're hiring college students to go out and look for the frogs in the desert, And they aren't finding any because they don't live there. We know where they are. They're on the private property up in the north end of the county, but we can't get on that private property. If you and the commissioners will help us do that, we'll give you a safe harbor agreement and we'll find enough spotted frogs to kill the BLM efforts for years. No love lost between the BLM and the Fish and Wildlife Service. So we did that. And in 3 days, they counted over 30,000 spotted frogs. Not only did they count them, but they found that the BLM argument had been that the cattle tramping around water would kill the spotted frogs. And what Fish and Life found was that the frogs used as hoof prints for nesting. It's strange how when real science is used, you get to the truth, as opposed to the kind of science that the BLM and CARB use, where you never get to the truth. The Ninth Circuit, to everybody's amazement, affirmed the judge and said coordination is one of the most basic of the laws. The judge went too far. He shouldn't have ordered the listing stricken. He should have thrown it out and made them start over. We did start over. They did relist it, and they took no action to enforce it from that day to now, and that was 23 years ago. In the meantime, Fish and Wildlife came into the commissioners on the last day I worked for them, and they said, we've got a real problem. We didn't do our research real well, and we have found millions of those snails up the Snake River, about 20 miles. And we have a problem. We have to kill the noxious weeds up there, and the snails are living on them. And we can't kill the noxious weeds without the snails, so we would like you to petition us to be your agent in doing that, and then we can do it. And I think I let the commissioners answer before I did, and their answer was the same, no thank you. It seems like it's your problem, you have to work it out. Now, those are 3 times that coordination went to court. Each time we won. In California, in Native Plant Society, the city of, you gotta help me again. Cordova had in their plan the requirement of coordination. They required Fish and Wildlife coordinate with them, and they didn't. And Fish and Wildlife, the federal government, went to court and said they violated the law. And the court in the California case went beautifully beyond what Congress had done in defining coordination. Set aside the plan and made them start over. There's another California case involving the water users in the north, where the word coordination was used in making them go back and start over. Now, there have been times that I have had to threaten a lawsuit in California to get coordination. In Siskiyou County, over the destruction of the dams on the Klamath River, I wrote a letter threatening the lawsuit, and the secretary said he would not issue the order to destroy the dams. We threatened the chief of the Forest Service with regard to 5 counties for reopening the travel management plan in California, and he backed away and ordered coordination. In Wyoming, the Forest Service had decided to close down all the campgrounds in Fremont County, and that's the only income they have left. They have no grazing, they didn't discover coordination in time. They have no forestry, they're just right outside Yellowstone, and so camping and the professional guides, that's their business. The reason for closing them is that the trees were diseased, and they were afraid the trees would fall and hurt the campers and there'd be liability. Naturally, you don't cut the trees down because they're sick. You close down the campgrounds. So we went in there and insisted that the Forest Service coordinate with us. The supervisor who was there said, well, I'll have to contact my regional forester and the solicitor, and I said, well, you already have. You called them yesterday. They told you you had to coordinate. And she looked a little stunned and said, okay, I think we can do that. Well, at the end of the plan, she announced that the plan was ready, it had been sent to Washington, and as soon as the department approved it, they'd bring it back and share it with the board. And I said, no, that's not the way you do it. You share it with the board now. You attempt to resolve inconsistencies now. You reach consistency now, then you send it to DC. No, we can't do that. That's not our policy. And that's one of the 6 letters that I've written to the Department of Justice, not to the Secretary, but to the Department of Justice, threatening a lawsuit for failure to coordinate. And within a few days, she called the board and said, you must have misunderstood me. Of course we intend to sit and coordinate with you. The Department of Justice does not want these cases to go to court. But we have in this situation one of the least transparent, one of the most arrogant, one of the most authoritative agencies that I've ever witnessed. I thought the Texas Department of Transportation was tough when we took them on with coordination and the Trans-Texas Corridor. I thought they were tough. They have a budget the size of Southwest Airlines. They have their own airline. They have 8 planes that travel all over the state and take their people around. I offered to let them take me around to the various meetings, but they turned that down. 4 little towns. I think you said that Colfax is 1,900, 1,500?
1.2 square miles.
These 4 little towns had a total population of 6,000. And they had chosen East Central Texas to put that roadway through because they knew nobody out there had the funds or the means to fight them. They were taking 40,000 acres of the prime farmland in the world, the Blacklands Prairie, which the state of Texas has said is hallowed ground. You don't disturb that ground. But when you're going to have a Spanish company build a quarter-mile toll road for you at no cost, on a no-contest bid, and own all the land along that road and own the toll road itself, you overlook things like hallowed ground. And that's what was to happen. The Spanish company would own the road, they would own all of the utility easements, so every utility company would have to relay its lines at the cost of the users. They would own all the businesses along that toll road, and all they had to do was widen the existing I-35, which was 100 miles to the west, and they wouldn't have had to destroy this environment. But it would have been so costly because the Spanish company would have had to condemn the land through the state, and it would have cost them more than buying what became worthless land from the farmers. So we undertook coordination for those 4 little towns. And the state came along first because there was a state statute requiring it. And then we told the EPA in Houston that they had to come in and coordinate. They wrote a nice letter saying they didn't see why, and we wrote a nice letter saying why. And so they showed up. They sent their chief EPA lawyer. I still have the video of this. It's a dandy. He gave an excellent argument as to why they didn't have to coordinate. And then I spent 15 minutes going through their own rules and showing why they did have to. And he looked at me and he said, uh-huh, and sat back in his chair, and they coordinated. We held off the draft environmental statement for 27 months. And finally, the Federal Highway Administration told Texas and told the Spanish company and told the EPA, you'd better withdraw because these folks have a record on which they're going to beat you in court. That's where the idea came for these kinds of hearings, where we present enough evidence to be a record that we can go on and beat the agency in court. And the governor withdrew that corridor because, as he said, he had listened to the voices of Texans. The governor doesn't like me. He refused to speak at lunch at a convention in Washington because I was scheduled to speak in front of him. He wouldn't agree to speak until I was scheduled behind him. And so we did that, but then we talked with a very good friend from a television station. And that night when it was showing him speaking, it was running my voice across the bottom. And he really didn't like that. At any rate, coordination is real. It's not a snake oil theory, it's in the law, and we've proven that the law has been violated. As to due process, now why do we go into the other issues? We go into the other issues because when you get into court and you're there because there is a black and white rule, it gives you standing to be there. Then you raise the other issues from your record to show the court what got fouled up because they didn't coordinate. All the questions that you've asked today could have been asked of the agency at the time they were developing these. They would have had to face these issues a long time ago, and they haven't had to. Ladies and gentlemen, we slept through the spotted owl. We almost slept through the sage-grouse. And there is no difference between these filters and a species. They're done for the same reason. They're done for control. And you've heard from these last two witnesses, it's control not only of truckers, but of every business that uses truckers. It's for control of the diesel industry in California and every business that uses those trucks. And it's control that is based not on fact, as you've heard, especially from Dr. Dunn, but on the basis of conclusion. The evidence that we offered in Reading, which will be in the record before all of you, is that John Beal reached out into the sky and pulled out 2.5 with no science behind him, but he pulled it out so that he could gain favor with his superiors, who happened to be Gina McCarthy and Miss Mary. They were the two that accepted 2.5 without any science. Having gained that position, he then didn't come to work for 2 years, claimed to be a spy for the CIA, and that's why he wasn't at work, collected 2 years' salary, and is now doing prison time. This is the man that created the 2.5 standard that is being thrown down the throats of Californians. And the statistician who worked with his figure out here bought his PhD from a storefront in New York City. You saw from the chart that we put up yesterday, he's still working, still making $98,000 a year from the state of California. Beal is not so lucky. He's in a federal prison, and he owes a big fine when he gets out. California deals with crooks far easier than Washington, D.C. when they get embarrassed. Due process. That's a violation, first of all. To come up with a standard with no scientific base, that's a violation of due process of law, substantive due process of law. And then you heard Mr. Atkinson. He doesn't even know, they don't even know what fine to impose on him. They'll decide. And the staff will decide, not the board. The staff is going to decide what fine to impose on him. The Supreme Court for 100 years has said no person can have a fine or a penalty imposed on them unless they know in advance what they need to do to be right and what the penalty will be if they don't. Due process violation number 2. Everybody who testified in this case who passed the smoke test from the standpoint of comparison of what would satisfy the rule has been denied due process of law. When a person is told, when a person from CARB is told about the test, and he says you have to have a filter, you have to have a filter. You have to have a filter, a violation of due process of law, because, and when they say zero, you have to have zero emission, that means there is no law. That means that regulation is not even the law. And it means that just exactly what they've said, we do what we want. That is due process violation. We have people who have given their lives for 200 years to protect the Constitution. And these people in Sacramento have wiped it aside as though it doesn't exist. That in itself is a violation of due process of law. The Interstate Commerce Clause doesn't mean anything, apparently, to Sacramento, but it meant something to the Supreme Court of the United States, which went through 30 years of pretty brutal debates back and forth as to what it really meant. And if you recall your constitutional history, it was one of the two reasons that the founders wrote the Constitution. There were only two reasons they went there. One was to make sure that there would be a funding mechanism for war, because that had failed under the Articles of Confederation. And the second was to make sure that interstate commerce was protected, because we had 13 sets of tolls and 13 sets of rules. And anybody traveling a stream through those 13 colonies had to pay a new toll at each state and new rules at each state. And they said, we can't have this, and so the founders committed treason. They went to Philadelphia with instructions from the states to simply amend the articles. And they were smart enough to know they couldn't do that because of those two reasons. They knew they had to write a constitution. If they could have seen on the middle of July, I don't know if any of you have ever been in Philadelphia in the summertime. My God, it's awful. The room they were in, every window was shuttered because they didn't want the people outside to hear what they were doing. So they're sitting there suffering, and most of them were from the country. They would have been in school and with their mint juleps and whatever, especially the Southerners. If somebody had told them at that time that someday, way out to the west, one of those problem western lands that you don't even know about yet, there will be an unelected, appointed board that will decide what the Interstate Commerce Clause means, and they will decide that they can interfere with it by establishing a rule that keeps trucks out of it. I really suspect they would have gone back to their hotels, packed their bags, and gone home. They worked hard to make sure that there's a document that would preserve the liberty in this country. Remember, this is the only republic in the history of the world that was ever created by men who believed that God was with them and guiding their hands. The only one. And for them to think that a group in Sacramento could undo that most important clause to them in the entire Constitution, I don't think would have sat well. I said in my other closing argument, I think they would have looked, if they were here today, and said, what the hell is this? What did we work so hard for? What have we fought all these wars for to protect that document? A document that still exists with what, 22 amendments in all, 26 in all these years? But CARB has found a way to amend it by breaking it and having nobody call them the cause for it. They've committed breach of contract. You heard the testimony of Ripke. He got a grant from him to buy a truck. It doesn't work out. He loses his business, turns the truck in, loses that, loses his equity in it, and then CARB comes back and sues him for the grant money. The grant was completed. He did what he was supposed to with it. He bought the truck. Does that mean anything to them? No more than it means to the people that they threatened with a $500,000 fine in order to collect $238,000. You know what the judges of the criminal bench in Baltimore called that? They called it malpractice extortion. A criminal attorney who did that with a client was subject to discipline from the Supreme Bench of Baltimore. Just a common walking around criminal attorney. And these people have put themselves in a position where they can do that, and what can he do about it? Does he have the money to fight him in court? And don't they count on that? They count on the fact that people, common people, hard-working people, don't have the money to fight them. Much to Mark and my problem, we don't like that much, and so we don't make a lot of money. They have, they've taken land and assets, and they have defamed and committed defamation against title. You heard the lady testify about the oyster farm that had to be destroyed. I'm willing to bet the value of anything I've got on that table that EPA is in that because it was a clean water action. And while the Park Service took the lead, as they often do, EPA was there. I know it as well as anything. They didn't offer her compensation. They don't even consider it a taking. Shasta Community College had to destroy perfectly good equipment. And they got compensated for it with tax dollars to buy other equipment, but they didn't get compensated for the taking of that money from the education fund. That's a regulatory taking. Every truck that you've heard about being destroyed is an example of a regulatory taking. What we're going to request when this record is completed is that you do several things. That you send your findings with a request to the Los Angeles District Attorney to begin an investigation and potential charges if the evidence sustains it against the University of California at Los Angeles and the University of Southern California and CARB and EPA for violation of the most basic law of morality that's involved in this case. We're going to ask you to send the same type of request to the DA of Sacramento County and to the Attorney General of the United States. And we do that with no expectation that any of those offices will do anything about it. But we'll have the record that you did it, that you gave them the opportunity. We're also going to ask that you send your decision to the EPA administrator, to the CARB director, chairman, and give them one more opportunity to answer the evidence that has been presented against them in these hearings through coordination. I don't expect that they will do that. They haven't in any of the other cases that we've done. And then there will be other people that we request that you send it to, including the Energy Oversight Committee with direct oversight of EPA. And better yet, the Subcommittee on Appropriations that is directly over the appropriations of EPA. And ask them to review this evidence and then refuse to appropriate money to the EPA that can in any way be forwarded on to CARB to implement their program. And then finally, hopefully, the Stand and Fight Club can raise enough funds through contributions that we file a lawsuit in the federal district court asking for an injunction against CARB an injunction against the EPA, and where the other cases have failed, we will have the coordination element there, and also ask for sanctions against those agencies for violation of those humanitarian laws. In the power of the Federal District Court, which is one of the most powerful, the courts have one of the most powerful authority in our government. They have such wide authority to take care of immoral actions that are done by government agencies than probably no more than 12 lawyers in the country know about. And fortunately, we have 2 of them here, at least. We're going to ask for those sanctions and punitive damages to help pay for some of the damages that have been caused to the people of California by the application without due process of law of a regulation issued by non-elected officials in violation of the Constitution of California and the Constitution of the United States. I drove out the other day. We actually took 3 or 4 hours off and drove up above Woodland, and I looked at those rolling mountains and the beauty of that country, and I thought, you know, this is Reagan's California that I grew up understanding and knowing. This is the Golden State that we always heard about. And then when I got home and I started looking at the pictures of businesses gone out of business, and I looked at a former gardening supply place in Woodland that had been in existence for 60 years and had to go out of business because of CARB non-compliance. I thought, and this is what Mary's done to it. And she has, single-handedly, with the help of some of these other people on there who I believe don't have the capacity to think independently, or even the capacity to think about the Constitution and think that it means anything to anybody. And that's what we're going to ask you to do. It's going to take courage to do it, because even though you won't be taking those actions, we're going to ask that the local governments and the non-government organizations who have had coordination denied, that you not pay for, but that you back us in that lawsuit if we get enough money to file it. That you back the city of Redding, which was the first one in. And they had the courage to do it when everybody told them, you don't want to take CARB on. And they did it. You folks have done the same by being at this board. They know about you. They know your meeting. They know they had the opportunity to come. But they don't think they'll ever have to answer to any of these things. Well, they will. All we need now is the funding to do it, and they will. I promise you they will. I can't promise a win, but to do a very bad paraphrase of Winston Churchill, I think what we can offer you is that to a very small group of people who participate in these hearings, if the state of California and the United States of America last for 1,000 years, they'll say these were your finest days because of what you could do for your state and your people. And when the record's complete, we'll present proposed instruction or proposed findings to the hearing officer for him to send on to you if they're within the parameters of the evidence. And we hope you'll follow those requests and win this thing for the people of California, and maybe save all those salaries up in Sacramento to be used to pay the punitive damages that I hope you get. Thank you all for your attention. I know that it gets to be long and tedious listening, but I do thank you, and we will have the report to you as soon as we can get the record closed and this fine lady gets us the transcript, and she'll be ready before we will. we ask you to then take the action that's necessary to make this wrong right. Thank you.
Thank you, Councilor.